So when I introduced you, I made the mistake of saying Nova Scotia University, and it's Nova Southeastern University, where you're a professor of law, so you're recognized for 5 minutes.
Thank you, sir. We're a distance from Nova Scotia, actually. Not a problem. Mr. Chairman, Mr. Ranking Member, and members of the subcommittee, my name is Joel A. Mintz. I'm a professor of law at Nova Southeastern University in Fort Lauderdale, Florida. Since 1983, a major focus of my academic research and writing has been the enforcement work of EPA. I've written 3 books and a number of book chapters and law review articles that touch on EPA enforcement. My most recent book, Enforcement at the EPA, High Stakes and Hard Choices, Revised Edition, which I actually have a copy of here for purposes of shameless self-promotion, was published in April by the University of Texas Press. That work, based on 190 personal interviews with government enforcement officials as well as extensive documentary research, recounts the history of EPA's enforcement program from its beginnings in the early 1970s through January 2009. Since 2009, I've also conducted a number of informal telephone interviews with enforcement personnel at EPA and the Department of Justice to get a continuing sense of the major EPA enforcement developments and trends during the Obama administration. My testimony before you today is intended to put the enforcement work of EPA during the Obama administration to date into context and historical perspective, rather than to discuss any individual cases or regulations. My main point is simple and straightforward. For the past 3.5 years, EPA's approach to enforcement has employed the same overall philosophy and strategy that have characterized EPA enforcement since the early 1970s. Rather than being uniquely overzealous or draconian, EPA enforcement in the Obama years has followed long-standing patterns established at EPA well before 2009. From the agency's beginnings in the Nixon administration to the present day, EPA enforcement, with only a few brief periods of exception, has been based on a theory of deterrence. Under this deterrence theory, which is scarcely unique to EPA, violations of the law are to be detected promptly and fairly and appropriately punished as a way of deterring the individual violator and others similarly situated from violating the law in the future. The theory assumes that individuals and firms are rational economic actors who will comply with the law when the probability of detection is great enough and the penalties are high enough that it becomes economically irrational for them to violate the law. Of course, the constitutional rights of all citizens must be strictly protected during this process, both because it's the right thing to do and because enforcement cases will not succeed in the courts where citizens' rights are violated. Throughout EPA's history, with only minor exceptions, decisions regarding which industries and companies should be the focus of enforcement actions and whether those actions should be administrative, civil, judicial, or criminal in nature have been made by career enforcement professionals and not by political appointees. From the George H.W. Bush administration through the Obama administration to date, for approximately a third of its enforcement work, EPA's enforcement staff has relied on a national priority approach that targets particular industries and national or international firms for intensive, comprehensive enforcement actions. This targeting approach is a neutral, non-political procedure that employs statistical analysis of data to give enforcement priority to industries and firms which have the worst compliance records and whose environmental releases do the most harm to the health of Americans. EPA's own annual enforcement reports provide statistical evidence that EPA enforcement under Obama has not been uniquely harsh. They reveal, for example, that during the 8 years of the George W. Bush administration, the civil penalties assessed against environmental law violators averaged $117 million per year. In contrast, during the first 3 years of the Obama administration, EPA enforcement resulted in assessment of a slightly lower average amount of civil penalties, $115 million a year. Similarly, EPA enforcement actions against the oil and gas industry declined during the Obama administration as compared with the preceding presidency. EPA brought only 87 enforcement actions against the industry in 2011, while it initiated 224 such actions in 2002. Although there may well be good explanations for these declines, they do support the overall conclusions of my historical research. EPA's enforcement work during the Obama period has been similar in nature to its work to the work it did in nearly every administration since the agency was established, regardless of the party affiliation of the president. Thank you.
Illinois, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman. Mr. Chairman, you asked the question of how many of the witnesses have been who have worked personally with the EPA. I would like to ask the witnesses, how many of the witnesses present at the witness table today were personally invited to testify at this hearing by the chairman or the chairman's staff? How many you, please raise your hands, how many were personally invited by the chairman or the chairman's staff to testify at the hearing today? Okay, let me ask it again. How many of the witnesses were personally invited by the chairman, Mr. Whitfield, or the chairman's staff? All right, thank you, all right. Everybody. My point is that 5 of the 6 witnesses were invited, all of them were invited, but the fact that 5 of them are representatives of industry, that's the point that I'm trying to make, and that they were invited. Only 1 witness is a Democratic witness. And we would like to have had more, absolutely. All right. Now, the point, I want to ask Dr. Mintz. The Associated Press examined 10 years of data on the EPA's enforcement of noncompliance by oil and gas producers, and according to their independent analysis, the number of enforcement cases against oil and gas companies in Region 5 and also across the nation has been lower every year under the Obama administration than any year under the Bush administration. In fact, the EPA reported that nationally, the number of enforcement actions against oil and gas producers dropped by 61% over the last decade, from 224 in 2002 to 87 in the year 2011. And the EPA notes that this decline has occurred even though the number of wells has increased, and EPA has listed energy extraction as a priority enforcement area. Dr. Mintz, are you familiar with this AP analysis? And if so, would you concur with the findings of this independent and unaffiliated analysis?
Yes, sir, I'm familiar with it, and to my knowledge, it's correct. From what I understand, EPA's statistics actually cover a somewhat broader range than just the oil and gas industry, I've been informed, but nonetheless, it's, I think, substantially correct, and I have no reason to doubt their figures.
As you can see, Dr. Mintz, and as I tried to point out, there are no witnesses today from the public health sector. All industry witnesses today, 5 of the 6 are industry witnesses today. They're from industry, none from the public health sector. They're all from industry. As a former chief attorney with the U.S. Environmental Protection Agency here in Chicago, and here in Washington, I wonder if you might briefly speak about some of the health impacts associated with air and water pollution that EPA and the Clean Air Act were initially designed to address.
Certainly, sir. I don't pretend to be an expert in public health issues or epidemiology, but just as a matter of general knowledge from my work at EPA, I know that the Clean Air Act was aimed at preventing or lowering the incidence of lung diseases, They are related to a number of types of emissions of pollutants, for example, sulfur dioxide, small particulate matter, and other kinds of emissions that can have a health impact.
I want to thank you. And, Mr. Chairman, I do have an open letter from 350 health professionals to policymakers in support of the Clean Air Act and the environmental, the EPA, that was submitted to my office. And I would like to submit both the AP report and also the open letter to policymakers. I'd like to submit that for the record.
Well, without objection, and I might say Mr. Smitherman, Mr. Shaw, and Mr. Etzity have responsibility for health issues. I'm positive of that because you enforce the Clean Air Act under your state implementation plan. Okay, at this time, I recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Dr. Armendariz is not here today, but he apologized for the comments he made 2 years ago in Dish, Texas, and he resigned. He also made it very clear that his comments were an inaccurate way to describe EPA's enforcement efforts. Critics of EPA claim that his comments provided, quote, a rare glimpse into the Obama administration's true agenda, end quote. They claim that EPA's general philosophy is to crucify and make examples of domestic energy producers so that other companies will fall in line with EPA's regulatory whims, end quote. They interpret his comments as proof that EPA is happy to take enforcement actions against companies regardless of whether they violated the law. Mr. Mintz, you're an expert on EPA enforcement. We're looking to you for a reality check. Who at EPA is making decisions about when to bring an enforcement action in specific cases? Are the decisions made by political appointees?
No, sir, not at all. They're generally made by career staff on a case-by-case basis.
Do EPA regional administrators dictate whether EPA takes a specific enforcement action?
Not typically, no.
We've heard claims that Dr. Armendariz's unfortunate remarks about crucifying oil and gas companies reflect the hidden agenda of the Obama administration. Mr. Mintz, based on your research on EPA enforcement, does the Obama administration's approach to enforcement differ significantly from past administrations?
No, it does not.
And the facts support that statement. According to nationwide enforcement data provided by EPA, the Obama EPA has taken fewer civil enforcement actions on average than the Bush administration. The same holds true for Region 6, which Dr. Armendariz led. The average amount of annual civil penalties across the country has not increased either. So that's the big picture. Let's take a couple of examples from this panel. Mr. Short, the regional haze issue you raised today isn't an enforcement issue, is it? This involves air rules and implementation plans, isn't that right?
That is correct. The state has the responsibility, along with EPA, to develop and implement a plan to address the regional haze piece.
And EPA issued a proposed rule on the state implementation plan a few days ago, indicating that the parties should discuss the issue to see if they can resolve it. Isn't that right?
Yes.
Mr. Etzity, are there areas where the Navajo Nation EPA has worked well with EPA? Are you supportive of their enforcement approach with regard to the remediation of abandoned uranium mines?
Thank you for the question. Yes, we have had good working relationships with EPA Region 9 and Region 6 addressing the problem of abandoned uranium mines and the cleanup necessary.
Well, Dr. Armendariz's poor choice of words did not represent some sinister, previously undisclosed EPA enforcement policy or philosophy. Frankly, the absurdity of the anti-EPA rhetoric coming from the other side of the aisle and from some industry groups is stunning. These extreme accusations are completely divorced from reality. EPA should be enforcing the laws on the books. That is common sense. Career professionals have been doing that important work for the last 40 years. Congress should be supporting their efforts, not attacking them with fact-free rhetoric. Thank you, Mr. Chairman. I yield back to Nancy.